Okay, in this video we're going to discuss the process of going from contract through closing and all the logistics in between for a subject to deal. Now the first thing you want to do is have the contract reviewed by either an attorney or your mentor or someone else who you're working with who's experienced at subject to deals, who can make sure you filled it out right. You got to make sure that the numbers are right, you got proper signatures. You know, one of the things that people don't realize is if there's more than one person on the title to the property, like husband and wife, and they're separated, you need both signatures. In community property states, for example, even though husband is the only one on the deed, the wife has a half interest by law, you need her signature as well. So be aware of who the owners are before you get a signature on the deed, or who's the necessary parties to sign on it. And if you make a mistake, no big deal, you just go back to the seller and make the revisions and have them re-sign it. Now be aware, if you're in a state, and there are about 25 of them, that have foreclosure protection laws, you have to put a clause in the contract that gives them the right of rescission. So it's different in every state. You can look it up, you can Google it, and find what are the foreclosure protections laws in each state. So you might have to put a clause that says that the seller has a 3 or 5 or 7 day right of rescission to rescind the contract, and then the deal is over if they do. They rarely do, by the way, but you have to give them that option, and then a form, which is a rescission form, basically, which just says I wish to rescind. You have to give them a rescission form. If you don't comply with that, you can get into big trouble. So make sure you are aware of that. Number 2, you want to verify title. That is, you want to make sure that there are no other liens on the property that they haven't told you about, seconds, judgments, other liens, and also that will verify the chain of title to make sure that they are the proper owner of the property. No one else has a claim against it. And when I say title company, by the way, I know in some states attorneys do it, some states it's escrow company, so whoever does your closings and pulls title, you can get them to do that. Number 3, you want to verify the loan. What loan are you taking subject to? Just because the seller says it's fixed at 4% doesn't mean that's the truth. He may not know any better. It may be an adjustable. It might have a balloon. The only way for sure to know is to get a copy of the actual note. Now, if the seller can't find it, you can usually go online to the bank's website and you log in and you can pull a copy. If not, you can call them up and ask them to fax one over. Now, the mortgage or deed of trust is public record. So when the title company pulls title, you can see what that says and see if there's anything weird in there. But it's important to get a copy of the note and review exactly what it is that you're taking over subject to. You want to do a closing at a title company, attorney, or escrow company office. Don't want to do it over a kitchen table, so you want to get disclosures and a closing statement. You want to make it feel and look like a real closing so they feel comfortable doing the deal. Besides, if it blows up and it comes out that you didn't do it at a title company or attorney's office, it tends to look suspicious, so do it at an attorney or title company's office. Now, if you call a typical title company, 7 out of 10 will say, we can't do a subject to deal without telling the lender. That's illegal. Well, most of them are actually wrong. It's not illegal. It's the lender's right to exercise, but it's not illegal. But they won't do it because they were told by someone who told them someone who told from someone that it's illegal, and that's all they know. Okay, but so don't get discouraged if the first couple of title companies you call don't do the transaction. All you need is one. So ask around, ask for referrals, and find one that does it. Now, at closing, that title company is going to make seller and buyer sign an indemnity agreement. That basically says you understand that we're not paying off the loan, and you agree neither of you to sue me with regard to the loan still being there, or if the lender finds out and decides to exercise the due on sale. Next, we have the seller sign the all-purpose CYA form. This is our disclosure to the seller about the implications of the deal, that it's still on their credit report, it's still their obligation, you're not assuming it, and etc. Now, all those things are in the purchase contract, but we want to get a second one at closing, and preferably signed in front of a notary, so we really cover ourselves in case they come back later and try to argue that they didn't understand and they try to sue you or whatever. Next, you want to get a limited power of attorney, an LPOA. A power of attorney is a document that gives you signing authority for someone else. Now, you don't want a general power of attorney over all their affairs. A limited power of attorney limited to the property and dealing with the lender with relation to the property. Okay? So we want to get that limited power of attorney. We want to set up escrow payments. So we go online to the bank's website, put in our bank account information, it sucks it out of your bank account, pays it directly to the lender, and that's the way it goes. If it's a bank that doesn't, for some reason, have one of those things online, then to have the seller write a letter that you send to the bank that says, please send duplicate monthly statements to this person, you. That way you could write a check. And don't worry about the check being different on the name. They're not noticing that. That's some clerk, who's opening the mail. So I wouldn't worry about that at all. And finally, the last thing you want to do is make sure you change the insurance on the property. Now there's a new owner, so if you took title in a trust or an LLC or a corporation or in your own name, which I don't recommend you do unless it's your own home to live in, you have to change the insurance to reflect the new owner. And by the way, that's how the bank usually finds out that the property's been transferred. They don't have spies at the clerk's office. They don't notice the different name on the check, but they do get a change of insurance coverage. And that's when sometimes, it may alert them to, want to enforce the due on sale. But again, most of the time the clerks who processes that at the bank are low-level people who don't understand anything about a due on sale because lenders haven't been enforcing that for more than 20 years anyway. So I wouldn't worry about that so much. Now, if the seller's underlying loan has an escrow for insurance, and you want to change that insurance policy, you might get resistance if the insurance company who insures that property doesn't do commercial insurance, because you're going from an owner-occupied policy to a landlord policy. So that insurance company might not be willing to do that, in which case you have to change insurance companies to a different insurance company and have them communicate with the lender, with the escrow, and so forth. And again, that could tip them off, but probably not. As a practical matter, even though the seller's no longer the owner, you or your LLC is, if you don't put the seller's name on there somewhere, sometimes the bank has a freak-out session, because what happens is the insurance information, let's say you change insurance, and some clerk at the bank has a computer program that says, is the borrower named on the insurance policy? And if the answer is no, it doesn't like that. It spits out a letter. Okay? So have the insured be you, and then you can have the seller/borrower be the additional insured, and that usually makes everybody happy.